Very good morning, everyone. I know it's a very high time and you are preparing for UPSC Prelims. So here, Dnyanadeep Academy brings you a very interesting program to revise your general studies in minimum hours possible. Today, we are going to start with Indian polity. Basically, here, our purpose is not to teach you Indian polity. Already, you are very well aware about Indian polity. You read everything in Lakshmikant. You know all the facts and all those things. Here, our main purpose is to give you a basic understanding about which topics are more important, which are less important, which should be read, and which are the most important sub points and subtopics in that particular polity chapter. So let's start with the topic. Today we are going to start with the first topic, that is salient features of the Indian Constitution. Now here what our main purpose is to pen. So here our main purpose is to give you basic understanding about what we are going to write over, study over here. So हाच पेन चालू का असं. पहिला पुस्तक. We'll resume in a minute. So let's begin with the topic. Is clear? Everything clear? So let's begin with the topic. Today we are going to study the first one topic, that is features of the Constitution, or the most important features of the Constitution. Now, before moving forward, one very important thing. Let's try to understand what this Constitution is. What is meaning of Constitution? In simple term, Constitution is nothing but fundamental law of the land. I'm not going to teach here, just main purpose is to give you basic definitions and important points. So first point is, what is Constitution? It is fundamental law of the land. Then comes a question, why Constitution is known as a fundamental law of the land? Two important reasons are there. First important reason, since or why Constitution is known as a fundamental law of the land, Constitution is a supreme law. Constitution is a supreme law in that land. Why it is a supreme law? First reason, it is equally applicable to everyone. And second reason, no one is above the Constitution. These two things. Constitution is fundamental law of the land. Why it is known as fundamental law of the land? It is supreme law of the land. Why it is supreme law of the land? Two most important reason. First reason, it is equally applicable to everyone. Second reason, no one is above the Constitution. So that's why we have this Constitution. Clear? So we are going to study all important features of this particular Constitution. We'll be studying these one by one, and in that case, we'll try to revise these features of Constitution in minimum time possible, so that we'll get a clear understanding of all these things. So first thing, we have seen Constitution is fundamental law of the land, right? Constitution is fundamental law of the land. Second thing we are studying here, majority part of the Indian Constitution has been taken from Government of India Act 1935. Now this is the important part. I am not going to work on philosophical part. We are going to study only the major part of Indian Constitution. So here, first fact that comes to our mind is, from where we have taken majority part of Indian Constitution. We have taken majority part of Indian Constitution from Government of India Act 1935. Basically, structural part of Indian Constitution has been taken from 1935. One important fact that you must remember is, though we have taken majority part of Indian Constitution from Government of India Act of 1935. For prelims, remember, this Government of India Act of 1935 never came into existence. Many of you might not be knowing this particular fact, but this Government of India Act 1935 was never implemented. So two facts we are coming to know. Majority part of Indian Constitution has been taken from Government of India Act 1935, and second, this Government of India Act 1935 was never implemented. This is second fact. Now, can we amend the Constitution? Yes, we can amend the Constitution by 368, Article 368. Never forget this particular article. Can we amend the Constitution? Yes, Constitution can be amended in three ways. We are going to study those three ways under Article 368. So, which is the most important amendment act that was made into the Indian Constitution? It was 42nd Amendment Act of 1976, which is famously known as a mini constitution. Why? Because under this 42nd Amendment Act, Indira Gandhi made an attempt to change fundamental parts of the Indian Constitution. She brought many more changes into the Constitution. That's why, first thing, can we amend the Constitution? Yes. We can amend Constitution by which article? Article 368, which is the most important amendment, 42nd Amendment Act. What it is known as? It is known as a mini constitution. So 42nd Amendment Act is known as a mini constitution. Another important part, unlike America, we have a single constitution for both center and state. Remember this thing. We have single constitution for both center and state. Some of you might feel the speed is higher, but my dear friend, basically the most important purpose of this lecture is to have revision and to give you most important bits. So please bear with my speed. Indian Constitution is one of the lengthiest constitution. Why it is one of the lengthiest constitution? Many reasons are there. Indian Constitution contains principles as well as provisions is the first reason. Second reason, impact of British rule. Third is geographical reason, that is we are having. I'm not going to explain these parts. If you come to my regular polity classes, I will explain every point one by one. But here our purpose is to go for MCQs, that is only for prelims. So I'm not going to explain these parts, just you have to remember these parts. So first reason, Indian Constitution contains both principles as well as provision. It is impact of British rule. Geographical reason. Next one is historical reason, is one of the reason. There is dominance of legal luminaries. When we look at Indian Constitution, original Indian Constitution had 22 parts and 8 schedules and 395 articles. Normally, I do not suggest to remember facts in the Indian polity, but this is not a fact. This is very crucial fact that every Indian must know. So when we brought this Indian Constitution, it had 22 parts, 8 schedules and 395 articles. Those people who do not know what all these things are, so basically Constitution is a kind of rule book. Then every book has various chapters. So Indian Constitution, which has various chapters, these chapters are known as parts of the Indian Constitution. First thing, Indian Constitution is a book. It has various parts, chapters. So these chapters are known as parts of the Indian Constitution. Every chapter has various points. So these points are known as articles of the Indian Constitution. And every article has a sub point, which is known as a clause and sub-clause of the Indian Constitution. So remember this thing, it is known as clause and sub-clause. And as we go through every book or many books into our daily life, we always go through certain important informative tables, informative sheets and informative pages attached at the end of that book. Same is the case. Certain important informative tables, books and informative sheets have been attached in the Indian Constitution, which are known as schedules to the Indian Constitution. So these are known as schedules of the Indian Constitution. So basically, Indian Constitution is a rule book, fundamental rule book. It has various chapters which are known as parts. Every chapter has various points which are known as articles, clause, sub-clause, and most importantly, our Constitution has important informative tables and informative sheets attached, which are known as schedules of the Indian Constitution. So when we look at the Indian Constitution, original Indian Constitution, it had total 22 parts, 8 schedules, and total 395 plus articles. Whereas original American Constitution had just only 7 articles. Original American Constitution had just only 7 articles. So Indian Constitution is known as one of the lengthiest constitution in the world, whereas American Constitution is one of the smallest constitution in the world. In second, Indian Constitution, written constitution. Written constitution, it means we have a proper book, Constitution of India. When we compare this thing with America and Britain, remember, America have a written constitution, that is Constitution of Federal America. But Britain, that is England, do not have a written constitution. Now here I want to make one thing very, very clear. If a question comes to your mind, does Britain have a constitution? Yes. Remember this line, does Britain have a constitution? Yes, Britain have a constitution. Is it written? No, it is not written constitution. Then what all are the parts of British constitution? So here one important thing that you must remember, what all are the parts? Basically all laws made by British Parliament is part of constitution. All amendments passed by British Parliament. Then various charters which are accepted by British Parliament, various conventions, traditions which are accepted by British Parliament, various judicial decisions which are accepted by British Parliament. See, here everywhere I am using a word, laws made by British Parliament, amendment passed by British Parliament, charters accepted by British Parliament, conventions, traditions accepted by British Parliament, various judicial decisions accepted by British Parliament is part of British Constitution. Everywhere I'm using a common word, that common word is British Parliament. It means I'm saying that Britain have a constitution. But when I'm saying this word Britain have a constitution, it means in this entire British Constitution, the major focus lies upon the British Parliament. British Parliament is one of the most influencing factor in British Constitution. That's why when we look at the political setup in Britain there is a parliamentary supremacy. I repeat this line once again. When we look at the British parliamentary setup in Britain, there is a parliamentary supremacy. This line is very, very important. Remember, in Britain we have a parliamentary supremacy. इसका मतलब ये है कि ब्रिटेन में पार्लियामेंट जो कुछ भी कहेगा वो फाइनल होगा. ब्रिटेन का पार्लियामेंट जो कुछ भी बोलेगा वही फाइनल होगा. ब्रिटेन, देयर विल बी ए पार्लियामेंट्री सुप्रीमेसी. We'll compare British Constitution, we'll compare American Constitution and Indian Constitution one by one. But here we are coming to few important points. First important point, in Britain, what Parliament says is final. So in Britain, there is a parliamentary supremacy is there. Now coming to this part, that is American Constitution. It is a written constitution. American Constitution is a written constitution. But just few minutes ago, we have seen American Constitution had just only 7 articles, right? It means very few things were written in the original American Constitution. Then comes question, who will interpret these articles? Who will have the right to give proper meaning to these articles? But because there are chances that when power goes into the hands of people, power makes people corrupt. A famous statement of Lord Acton, power corrupts and absolute power corrupts absolutely. So there are chances that when we write just only 7 articles, then there are chances that legislature, executive, judiciary might misuse and misinterpret various articles of the American Constitution. So that's why American Constitution had made judiciary the most important organ to interpret the Constitution. So in America, there is a judicial supremacy. What judiciary says will remain final. Now we are getting two extreme ends. On one side, there is a Britain where what Parliament says is final. In Britain, there is a parliamentary supremacy. On second side, we have America, where there is judicial supremacy. Correct? On one side, America, there is a judicial supremacy. On another side, there is Britain, where there is parliamentary supremacy. Where does India lies? So a simple feature is there. In India, we have synthesis of parliamentary sovereignty and judicial supremacy. I repeat once again, remember this thing. In India, we have mix of both. That in India, we have synthesis of parliamentary supremacy and judicial supremacy. Clear? So this is very simple thing that to remember. So basically these are few points. Another important point is Indian Constitution is written. It is a federal feature of Indian Constitution. Why? Four important points are there. Why Indian Constitution is written? So why it is called that written Indian Constitution is a federal feature? First thing, this federal feature, that is written Constitution, it provides protection to the states from encroachment by the center. I repeat once again, written Constitution provides protection to the states from the encroachment by the center. And second important reason, federal feature, written Constitution makes an attempt to give equal power to the states along with the center. So center is equal to state. Remember this thing. So we are trying to decode every point which are important for prelims. First, we have seen Indian Constitution is one of the lengthiest constitution in the world. Second, we are studying Indian Constitution is written. So since it is a written Constitution, we are studying it is a federal feature. Why it is a federal feature? Because written Constitution provides protection to the states from encroachment by the center. There is no need to explanation. We are studying, having this marathon for the prelims. It provides protection to the states from the center. Second thing, written Indian Constitution makes an attempt. I am not saying giving equally. Indian Constitution makes an attempt to give equal power to the states along with the center. So that's why written Constitution is a federal feature. So basically American Constitution is a written, but in America there is judicial supremacy. British Constitution is unwritten, but we have seen what all are the part of British Constitution, and in Britain what Parliament says is final. So that's why, remember, in Britain there is parliamentary supremacy, in America there is judicial supremacy, and in case of India we have synthesis of parliamentary sovereignty and judicial supremacy. Clear? Now move forward. Then comes the very important part. We have borrowed various features from various constitutions in the world. Here you could get a question on match the pair. This part is very, very important. You could get a question on match the pair. Which part has been drawn from which constitutions in the world? I repeat once again, this you have to remember. From which constitution we have taken which part into our constitution. This you have to remember. So this part is very, very important. But here one very important thing. When Constituent Assembly debates were going on, many Constituent Assembly members were against the borrowing features from various constitutions in the world. So when Dr. Babasaheb Ambedkar was discussing significance of all these features in the drafting committee and Constituent Assembly, many committee members criticized and they said, what's new in the constitution? You are saying that you brought this one, that one, this is the thing, that is the thing. You are saying so many things. What's new in your constitution? What you have, right? And they criticized Indian constitution as just a patchwork. You brought one patch, two patch, three patch from various constitutions in the world, and you brought a patchwork in front of us. There is nothing new in this constitution. So in Constituent Assembly, our constitution was criticized as merely a patchwork, to which Babasaheb Ambedkar replied very beautifully. Babasaheb said, India is a very infant democracy. We got independence just few days back. We are a very new democracy. But when you look at rest of the world, like America is there, France, Italy, Germany, Britain, Japan, so Ireland, all these countries are there. They have been democratic many years ago. They got independence almost 50, 70, 100, 200 years ago. We are not democratic country at that time. So all these independent democratic countries which are more than 100 years old, they had same pattern of problems through their growth. Baba Sahib said that every country went through same set of problems, same set of issues, and same set of difficulties in their journey to a full-fledged, good democratic country. So we must learn from them at which point of time what difficulty they suffered, at which point of issue what they suffered, what solution they brought into their constitution, what amendment they made into the constitution. We must learn everything from all these constitutions in the world, and that's why we borrowed all important features from rest of the countries in the world, so that whenever we face a problem in the days to come, we will have a ready-made solution in our hand into the constitution. To which he replied, Indian constitution is not a patchwork, it is a beautiful patchwork, so that Indian constitution will have progressive relevance. I'm using a word. Indian constitution will have a progressive relevance. Progressive relevance, it means we can use our constitution without any hindrances in the days to come. So he called Indian constitution not only a patchwork, it is a beautiful patchwork, because adding various features from the various constitutions in the world has gave a very good, what we can say, has gave a very good progressive relevance to the Indian constitution. Then here the most important point, which is very important for your prelims, is we have taken structural part from Government of India Act of 1935. Philosophical part has been taken from Fundamental Right of USA, DPSP of Ireland. So remember, whenever there is a question on which is the philosophical part of Indian Constitution, here remember the philosophical part of Indian Constitution is in DPSP and Fundamental Rights. Political part has been taken from England. So these three things are very, very important. Majority part of Indian Constitution has been borrowed from Government of India Act 1935. So we have taken structural part from Government of India Act 1935. Philosophical part has been taken from America and Ireland, and political part has been taken from England. Indian Constitution is a blend of rigidity and flexibility. Why it is said so? A very simple thing is there. I will explain in a very simple term. Remember, can we amend the Constitution? Yes, we can amend the Constitution under Article 368. Right. Now, this amendment of the Indian Constitution can be made in three ways. First is by simple majority. Right. First is by simple majority. Second is by special majority, and third is by special majority of the parliament plus at least half of the states saying yes to that amendment by simple majority. Now, we are studying why Indian Constitution is called as rigid as well as flexible. What is the reason that Indian Constitution is called as a rigid as well as flexible? To which we are replying under Article 368. Article 368 says we can amend the Indian Constitution by three ways. First is by simple majority, second is by special majority, third is by special majority of parliament plus at least, not only parliament, plus at least half of the states saying yes. By which majority? By simple majority. Now, when you make changes into the Indian Constitution by simple majority, it is one of the easiest method. That's why Indian Constitution is a flexible like England. So what I am saying, certain provisions of the Indian Constitution can be amended by simple majority. That's why Indian Constitution is called as a flexible. One additional word to it. What is that additional word? See, Constitution itself says, this line is very, very important, my dear friends. Constitution itself says those amendments that are made by simple majority should not be or need not be treated as amendment under Article 368. Article 368 has mentioned that we can amend Constitution by simple majority. But also, Constitution itself says that those amendments which are made by simple majority of Parliament need not to be treated as amendment under Article 368 of Indian Constitution. Why it is so? Because By simple majority, we make only cosmetic changes and not fundamental changes. I repeat once again, by simple majority, generally we make just only cosmetic changes and not fundamental changes. That's why they said that those amendments that are made by simple majority need not be treated as amendment under Article 368 of the Indian Constitution. Second thing, bringing amendment by special majority. And third thing, special majority of the parliament plus at least half state saying yes by simple majority. It is a very difficult thing. That's why Indian Constitution is a rigid. So this is the reason why we call Indian Constitution is flexible as well as rigid. So it is written over here. See it very carefully. What it says, some of the features of the Constitution cannot be amended very easily. So it is a rigid constitution. Flexibility, some of the features of the constitution can be amended very easily. That is by which majority? By simple majority. So we call it as a flexible constitution. So Indian Constitution is both rigid as well as flexible. American Constitution is very rigid. You cannot bring changes frequently and very easily in the American Constitution, whereas British Constitution is very flexible. Every decision, rule, regulation, act, judicial decision accepted by British Parliament is part of British Parliament. So British Constitution is one of the most flexible constitutions in the world. We have federal system with unitary bias. So basically, it is based on the political setup of a nation. Which kind of political setup is available with the nation? We call that particular nation as a federation or unitary state or union of state or confederation. We'll try to understand these four words. Here, the four words that I'm going to explain you will be useful for the topic which is known as match the pairs. It will be useful for match the pairs. Before that, these two words are there that we are going to study. One is federal features. See, from now onwards, wherever word federation or federal comes, always remember the word federation or federal is favorable to the states. It is favorable to the states. Clear this thing? Wherever and whenever the word federal or federation comes, remember it is favorable to the states. Right? Now, what are federal features? Simple line is there. Those features of the constitution which protects states from encroachment by the center, and those features of the states which makes an attempt to give equal power to the states at par with the center are called as federal features. So remember, federal features favors whom? They favors state governments. Unitary feature, those features which are completely in favor of central government are known as unitary features. Those features which are completely in favor of central government are known as unitary feature. Clear? So we have a federal system which is biased towards unitary government. So it means our constitution, now this line is very, now I will explain this particular line. Listen very carefully what it means. See, we have a federal system. Our political setup is a kind of federal political setup. Now what it means? We have a federal system. What it means? It means our constitution has made an attempt to give equal power to the states at par with the center. Our constitution has made an attempt to give equal power to the states with the center. Also, our constitution has made many provisions which will protect states from center. That's why we have a federal system. But our federal system is more biased towards central government. That's why we have a federal system with unitary bias. Simple line, कोई भी पॉलिटिकल सेटअप जो स्टेट गवर्नमेंट्स को सेंटर के बराबर पावर्स देने का अटेम्प्ट करता है, जो स्टेट गवर्नमेंट का प्रोटेक्शन करता है सेंटर से, उसको हम फेडरल सेटअप कहेंगे। और लेकिन हमारा ये फेडरल सेटअप जो है ये केंद्र सरकार को फेवर करता है, इट इज मोर फेवरेबल टुवर्ड्स द सेंट्रल गवर्नमेंट, दैट्स व्हाई we have a federal system which is biased towards the central government. So we have seen what are federal features, we have seen what are unitary features. Now here we'll try to understand few important words. Which country will be called as a federation? So here basically a country which is formed out of agreement between the states, right? Because the word federation comes the term fidus, which means agreement. A country which is formed out of agreement between the states will be called as a federation, where states will have equal rights with the center. So first important word is agreement, second important word is center is equal to state. So federation, a country which is formed out of agreement between the unit states, and a country where center is equal to state is there, is called as a federation. That's why America is one of the first and oldest federation in the world. Clear? Basically here states have equal right with the center. Second is unitary state. Which are unitary states? Those states where central government is all powerful than the states. Those states where central government is all powerful than the states is called as a unitary state. England is one of the most important unitary states. So we are getting two important extremes. On one side federation, that is America, on second side there is Britain, which is unitary state. In America center is equal to state is there. In Britain central government is all powerful. In Britain states are known as provinces. So in Britain provinces do not have any rights. Everything lies in the hands of a central government. Confederation, when certain states or certain countries, certain nations or certain institutions and organizations, they come together to fulfill their temporary interest. The important word is temporary interest. And once their temporary interest is fulfilled, they move away from that agreement. It is known as confederation. So basically confederation is famously known as a loose federation. That is loose agreement for fulfilling certain temporary interests, and once that those temporary interests are fulfilled, then these units will move away from each other. It is known as a confederation. Basically one confederation is Belarus, Russia, Kazakhstan. Second important confederation is Benelux. Benelux stands for Belgium, Netherlands, Luxembourg. Benelux stands for Belgium, Netherlands, Luxembourg have a confederation amongst them. Belgium, Netherlands, Luxembourg. Now these are most important statements from the prelims. I mark it down in your notes or everywhere. These are the most important statements. First thing, this particular notes of polity is available on our Dnyanadeep Academy's app for download at just only I think 40 or 50 rupees, or you can purchase hard copy from any store for these particular notes. These are available in the English. So 4 important states. India is not a federation of states. Why India is not a federation of states? First, India is not formed out of any agreement between these states, right? India is not formed out of any agreement between these states. That's why India is not a federation of state. Second, no state has the right to secede away from Indian Union, right? No state can move away from Indian Union. So these are the 2 most important reasons. India is not a federation of states. Why? First thing, India is not formed out of any agreement between the states. Second, no state has the right to move away from Indian Union. इसका मतलब यह है कि कोई भी राज्य हमारे देश से बाहर जा नहीं सकता है. That's why India is not a federation of state. India is a union of states. But Indian Constitution is federal in nature. Now, this is confusion. India is not a federation of state, but Indian constitution is federal. Here we are talking India as a nation. Here we are talking about our constitution. Constitution provides you directives to run this country. India as a nation provides you setup, structure of your nation. That's why Indian constitution is federal in nature. Why it is federal in nature? First, Indian constitution makes an attempt to give equal power to the states at par with the center. So equal power. And second, Indian constitution provides protection. Indian constitution provides protection to the states from encroachment by the center. Indian constitution provides protection to the states from encroachment by the center. That's why Indian constitution is federal in nature. And most importantly, federalism is the basic structure of Indian constitution. Federalism is the basic structure of Indian constitution. And that's why India, these four statements are very, very important. Federalism cannot be taken away. These two things cannot be taken away. Which is the most important landmark case where we got this word basic structure? Anyone please put the comments. Which is the most important case where we got this word basic structure? Basically, it is Keshavananda Bharati case. It is Keshavananda Bharati case of 24th of April 1973. Keshavananda Bharati case of 24th of April 1973, where we got this term basic structure of Indian constitution. These four statements are very, very important. So India is this we discussed. India is not formed out of any agreement between the states, and second, no state has the right to move away from Indian Union. That's why India is not a federation of state. Now this line is important. India is an indestructible union. Indestructible union. In simple term, union. See, two important terms are there. One is territory of India, and second is Union of India. Here remember, the word territory of India is larger than Union of India. I repeat once again, the word territory of India is larger than Union of India. I will explain this point. It is very interesting. One word is territory of India is larger than, second is Union of India. Why? Because the word territory of India includes all the states in India, all union territories in India, all acquired territories in India. Acquired territory by war, by peace, by treaty, by purchase, by lease, by any means. So the territory of India includes all the states in India, all union territories in India, and all acquired territories in India. So territory of India includes all these things. Union of India includes only states. Union of India includes what? It includes only states and nothing else. That's why the word territory of India is larger than Union of India, which includes what? It includes only the states. Correct point. Now, since the word Union of India includes state, this union is indestructible. Indestructible means which cannot be destroyed. This union is indestructible, means it cannot be destroyed. It means no state can move away from Indian Union. कोई भी राज्य अपने देश से बाहर नहीं जा सकता है. So this union is indestructible but of destructible states. मगर हम स्टेट्स को डिस्ट्रॉय कर सकते हैं. डिस्ट्रॉय कर सकते हैं मतलब तोड़ नहीं सकते. द वर्ड इज डिफरेंट. मतलब हम स्टेट के एरिया को, बाउंड्री को छोटा कर सकते हैं. अंडर विच आर्टिकल? अंडर आर्टिकल 3 of the Indian Constitution. Under Article 3 of the Indian Constitution. Correct? Now, I repeat this line once again. India is an indestructible union. मतलब इंडिया से कोई भी देश बाहर नहीं जा सकता है of destructible states. इसका मतलब है we can change the state. So India is an indestructible union of destructible state. Destructible state, we can change an area boundary of a state. I will just explain you Article 3 in short, which is also important for prelims. So what Article 3 says? See, this topic is very important because it is basic. Once you are very clear with this topic, then all other topics are very easier, very smoother, and we are going to continue this entire Lakshmikant over a time period. हम ये पूरे अप्रैल एंड तक आपका पूरा का पूरा लक्ष्मीकांत और बाकी सारे के सारे सब्जेक्ट का रिवीजन करा के लेंगे, पक्का करा के लेंगे. Just have a patience. Now, Article 3 says, what Article 3 says? First, it says we can change name, area, boundary of a state. We can add two states. We can divide a particular state. We can attach a part of state to any other state. So we can change name, area, and boundary of a state. Name, area, boundary of a state. Now, the right or the authority to change name, area, and boundary of a state lies in the hands of Parliament only. State governments do not have any right. As per Article 3, the right to change name, area, and boundary of a state lies in the hands of Parliament only. Correct? Now, before starting this particular process, that draft bill which is being put into the Parliament must have assent of the President. So under Article 3, assent of President is very, very essential to put a draft bill into the Parliament. Now what President will do? President will send this bill to the state legislature to express their views. Within specified time. This is important. States do not have liberty to decide. I repeat once again. Under Article 3, whenever Parliament wants to change name, area, and boundary of a state, this bill must have assent of the President. What President will do, after giving that particular assent, President will send this bill to state legislature to express views of the state legislature within specified time. This specified time shall be decided by President only. And once those views of that state come, remember, the act will be taken by Parliament for passing. Here, important thing, the views expressed by state, right? Views are not binding. Views expressed by state are not binding either on the President or on the Parliament. Remember, views expressed by state are not binding either on the President or on the Parliament. And the most important thing, name, area, and boundary of a state shall be changed by which majority? Simple majority. Remember this thing, name, area, boundary shall be changed by simple majority of the Parliament. This is Article 3. So states are vulnerable. In India, states do not have territorial integrity. UPSC Prelims will ask you this particular word, or they might give you this particular line. In India, states do not have territorial integrity, unlike America. In America, all these states have their own proper territorial integrity. Whereas in case of India, Indian states do not have territorial integrity. Their name, area, boundary can be changed by Article 3. Authority lies in the hands of Parliament. Assent of President is essential. President will send the bill to state legislature to express their views in specified time. Views of the state legislature are not binding upon the either President or Parliament, and Parliament will make changes into that particular name, area, boundary by just simple majority of the Parliament. That's why this particular line, that in India, India is an indestructible union of destructible states. These are important opinions about Indian Federation. Why I have given this opinion? Because these are very, very important for the point which is called as match the pair. UPSC might ask you, so try to remember anyone. It is match the pair. constitution is federal in form but unitary in spirit. It is quasi-federal said by K.C. Weir, bargaining federalism Maurice Jones, cooperative federalism Granville Austin, federation with centralizing tendencies Ivor Jennings. I gave you just only keywords, but this part is very, very important for all preliminary examinations to which you are appearing in all over India examination. So these opinions are very, very important. Here you will definitely get a question on match the pairs. Then we have parliamentary form of government. We are going to study this point in detail as a parliamentary form of government. But before that, the important thing, Article 163 and 164 in the states and Article 74 and Article 75 in the center. These are the basis of parliamentary form of government. You could get a question, which among the following articles are the basis of parliamentary form of government? So remember Article 74 and 75 in the center and Article 163 and Article 164 in the state. These are the basis of parliamentary form of government in case of Indian Constitution. Now we will study all these things in that separate topic, parliamentary form of government. Now here we have synthesis of parliamentary sovereignty and judicial supremacy. Why? We have seen, I will just repeat it over here. Let's think about Britain. In Britain, do they have constitution? Remember, Britain have a constitution, but their constitution is not written. Like in case of India, we have Constitution of India. In America, we have Constitution of America. We have two separate books. For India, we have a book. For America, we have a book. But Britain do not have a separate book. There is no separate book which can be called as a Constitution of Britain. Then, British Constitution is from what? Majority influence lies in the British Parliament. Laws made by Parliament forms the major part of British Constitution. That's why we have in Britain parliamentary sovereignty. What Parliament says is final. It is procedure established by law. I have taken a complete separate lecture on Article 21. I will put that lecture on this our YouTube channel. So please go through that particular lecture. What is the meaning of the procedure established by law? Please go through that lecture. What is procedure established by law? But in Britain, there is a procedure established by law. So it is Britain. What Parliament says is final. When we compare same thing with America, they have a written constitution, one of the smallest constitution. It contains only principle. In America, there is judicial supremacy. What judiciary says will remain final. That's why they have due process of law. In America, there is a due process of law. Just try to remember these two separate lines. In Britain, there is a procedure established by law. That is what law says is final. In America, there is due process of law. Here what law says is not final. What are the good intentions of law are final. What are implicit intentions of law are final. Wordings of law are not important. Contextual interpretation from the perspective of constitution, from the perspective of democracy, from the perspective of popular sovereignty, from the perspective of people's welfare is supreme. So here words of law are not important. Here what is important? Here intentions of law are more important. That's why in America there is a due process of law. I have taken a complete separate lecture on Article 21. I will give that lecture. Please go through that lecture. It is very important, not only for the examination. That Article 21 is very, very important for your understanding of the Constitution. Why Article 21 is known as colorless legislation. Why Article 21 is so supreme. You will come to know that part. So we have two extremes when we come to India. In India, we have obtained the synthesis. Sorry, I will just explain. I will just read it, what it says. In India, we have obtained the synthesis of these two extremes. In India, we have the synthesis of parliamentary sovereignty and judicial supremacy. In this way, both these institutions will act as a Here word is check. So in this particular way, what conclusion says? It says in this way, both these institutions, that is parliament and judiciary, both these institutions, parliament and judiciary, will act as a check and balance upon each other. This will help to protect the democratic credentials of the Indian Constitution. It will help in protecting democratic credentials of the Indian Constitution. It is supported by Article 21, right to life and personal liberty and basic structure of Indian Constitution, which you got where? In Keshwananda Bharti case on 24th of April 1973. Now, important thing, in India, we have integrated and independent judiciary. Now, many of you are not my students in the regular classroom, so I will explain you what is meaning of separated and integrated judiciary. Though it is not important to explain, but many of these students are not of my regular classroom. You are a YouTube student, so I will explain you what is integrated and what is separated judiciary. Here, let's try to understand. In India, we have integrated judiciary. In India, we have integrated judiciary. Means what? Let's imagine Maharashtra, Karnataka, Goa, and Gujarat. We have these 4 states. Now, what is the hierarchy of judiciary? A layman's hierarchy, not proper judicial hierarchy, a layman's hierarchy. What is the hierarchy? Here it is a lower court, district court, then we have high court, right? We have high court. Same, lower court, district court, and finally high court. Lower court, district court, high court. Correct. So, High Court can adjudicate upon what? It can adjudicate upon state law. Here comes High Court, it adjudicates upon state law. So, every state have their own separate High Court. But if you are not satisfied with the verdict and judgment given by High Court, you can appeal to the Supreme Court situated in New Delhi. You can appeal to the Supreme Court situated in New Delhi. It means Supreme Court has the right to adjudicate upon union law as well as state laws. That's why it is known as an integrated judiciary. We have single judicial system for both union laws as well as state laws. I repeat once again, we have single judicial system for both union law as well as state laws. Clear? We'll come to the distinction once I explain you the American separated judiciary. See, let's think about USA. They have separated judiciary. What they have? Separated judiciary. Let's take an example. Here it is New York State is there. Then there is a Texas. We'll take 2 examples only. Now same hierarchy. Like here lower court is there, then district court, then high court. Same like India. Lower court, district court, then comes high court. This was similar. But one very important thing. New York will have its own separate Supreme Court. Texas will have its own separate Supreme Court. High Court of New York and Texas High Court will not go to any common court. So, the Supreme Court of New York has the right to give final judgment on state law. It is final authority to judge on what? On state law. Here, it is final authority to judge on state law. Right? For state law. So, they have separated judiciary. Supreme Court of a particular state in America lies in that state only. Supreme Court of a particular state in America lies in that particular state only and nowhere else. Correct? Does it mean America do not have any Supreme Court or higher judiciary? Yes. They have a higher judiciary which is known as a Federal Court of America. Federal Court of America or Federal Court of Appeal. But this Federal Court of America have right to adjudicate only union laws and constitutional laws. Federal Court of Appeal in America do not have right to appeal upon or to take any case of any state. So that's why they have separated judiciary, unlike India where we have integrated judiciary. USA there is a separated judiciary that we have seen. Another important point, which all are the important features of Indian Constitution which helps us or which make it independent, will be definitely getting a question. Just search all the points which make Indian judiciary independent. Search all the points which make Indian judiciary independent. They are very important for your prelims. Which features of the Indian Constitution make judiciary independent? This kind of question will be asked definitely. Next important feature is fundamental rights. We are going to study the topic fundamental rights in detail. But here, few important things. First thing, fundamental rights are given in part 3 of Indian Constitution. Objective of fundamental right is to have political democracy. It is justiciable part of Indian Constitution. That is, if at all any part of the Constitution or fundamental right is not implemented, you have right to approach Supreme Court under Article 32 and under Article 226. Supreme Court, High Court. It is called as justiciability. Fundamental rights are justiciable part of Indian Constitution where you can approach Supreme Court under Article 32. You can approach High Court under Article 226. Clear? So it is justiciable part of the Indian Constitution. Fundamental rights are not absolute. It means they are not available as it is. There are certain reasonable restrictions imposed upon fundamental rights. Fundamental rights. Then comes directive principles of state policy. I'll just explain you what it means. Here, what is meaning of policy? It means desired course of action. What you want to achieve in the days to come. So DPSP, desired course of action, it is called as policy of whom? Of state. Remember, the word state is defined in Article 12 of Indian Constitution. I repeat once again, the word state is defined in Article 12 of Indian Constitution. So what all directives in the form of principles given to the state to have a welfare state is known as directive principles. Basically, DPSPs are constitutional instructions. I repeat this word again. Basically, DPSPs are constitutional instructions given by Constitution to state to establish a democratic welfare state. Right. I repeat once again, what are DPSP? DPSPs are nothing but constitutional instructions given by Constitution to the state, which is defined in Article 12 to establish a democratic welfare state. It is given in part 4. Its objective is to achieve socio-economic democracy. It is non-justiciable part of the Indian Constitution. Remember where I used word justiciable, non-justiciable, and I will star mark the points which are important for our prelims. So DPSP is non-justiciable part of Indian Constitution. Then comes fundamental duties, which were not original part of Indian Constitution. We added into the Indian Constitution based on the recommendation of Swaran Singh Committee under 42nd Amendment Act of 1976, which is famously known as a mini constitution. 42nd Amendment Act of Indian Constitution has added how many duties? It added 10 fundamental duties into the Indian Constitution and added Article 51 capital A. Remember, whenever there is a capital letter attached to any article, it is added by amendment. Whenever a capital letter is attached to any article, it is added by amendment to the Indian Constitution. Clear this thing? So fundamental duties is not original part of Indian Constitution. Article 51 capital A, Swaran Singh Committee, 42nd Amendment Act added how many duties? 10 duties. Then came another Amendment Act, that is 86th Amendment Act. This 86th Amendment Act of 2002 added 11th fundamental duty. And star mark, fundamental duties are non-justiciable part of Indian Constitution. That is, if a person do not follow fundamental duties, we do not go to the court, unlike Article 32 and 226, which are available as a protection to the fundamental right. So if we compare, if you make a chart, we are getting very important chart: fundamental right, fundamental duty, DPSP, and preamble. Right? Out of these four, only fundamental right is justiciable. Only fundamental right is justiciable. All these three are non-justiciable part. All these three are non-justiciable part of the Indian Constitution. India is a secular state. India is a secular state. Remember, the word secular was added by 42nd Amendment Act. Word secular is added by 42nd Amendment Act, but the most importantly, the word secular is not defined anywhere in the Constitution. Why we do not define a word? Because our main purpose is to avoid blocking of progressive interpretation. Whenever we define a particular word, it gets blocked. That's why the word secular is not defined anywhere in the Constitution. We have a word secularism. Another important fact regarding prelims: nowhere there is a word secular state. Word secular state cannot be found into the Constitution. We have just only word secularism. Not secularism, secular. Socialist, secular, integrity. Only these three words are there, added by 42nd Amendment Act. For your prelims, two types of secularism is there. One is positive secularism, second is negative secularism. Positive secularism, when state treats all religions equally. When state treats all religions equally, it is known as a positive secularism. India is one of the best example of positive secularism. Negative secularism, when state do not recognize any religion. State treats every person as a citizen, irrespective of his caste, creed, race, color, sex, or religion. It is known as negative secularism. Negative secularism is a Western concept. And most importantly, negative secularism is more advanced as compared to positive secularism. Negative secularism is more advanced as compared to positive secularism. For your prelims, they will ask you a question: which among the following provisions of the Constitution manifest secularism? So these are the provisions of the Constitution which manifest secularism. It is important. This is very important. Remember this thing. Take a screenshot of this particular line. All these features or the parts of the Constitution which manifest secularism are very, very essential. These manifest secularism. Preamble, Article 14, 15, 16, 25, 26, 27, 28, 29, 30 and Article 44. These are provisions of the Constitution which manifest secularism. Then we have universal adult franchise. Under universal adult franchise, you have to remember three simple things. One is Article 325, second is Article 326, and third is 61st Amendment Act. Before that, the word universal adult franchise belongs to Article 326. इसको स्टार मार्क कर लो, ध्यान में रख लो, प्रीलिम्स के लिए इंपॉर्टेंट है. Universal adult franchise is applicable to Article 326. What Article 326 says? Every citizen of India who is more than 18 years of age is eligible to vote. Every citizen of India who has completed 18 years of age is eligible to vote. Is Article 326. What is the significance of 61st Amendment Act of 1988? 61st Amendment Act of 1988, it says that it reduced voting age from 21 years to 18 years. 61st Amendment Act reduced voting age from 21 years to 18 years. This is important. Basically, it was in 1988. Implementation started in 1989. And what is significance of Article 325? Article 325 says that you should not discriminate amongst the citizen based on any reason while inclusion of that person in electoral voters list. So it says no person shall be ineligible to be inclusion in or to claim to be included in a special electoral roll on grounds of, what are the grounds? Religion, race, caste or sex. So basically Article 325, no discrimination. Article 326, universal adult franchise, and 61st Amendment Act reducing voting age from 21 years to 18 years. This we have seen. Then another important feature is we have single citizenship. In simple term, we have a single citizenship. Unlike America, where there's a dual citizenship, every person will have a citizenship of a state as well as nation. In case of India, we have citizenship of India only. We have a single citizenship. Then there are certain important independent bodies, independent constitutional bodies, independent constitutional authorities, which will work in India to maintain independence and integrity of the Indian Constitution. So there are certain independent bodies. They are Union Public Service Commission and all those things. Emergency provisions, very very important. Emergency provisions पे अपने को सवाल आएगा, यहाँ पे ये पार्ट ध्यान में रखना है, पार्ट 18 कैसे याद रखना है? पार्ट 18 it starts from E, so E and E. रिमेंबर पार्ट 18 बेसिकली बहुत बार क्या होता है ना, यूपीएससी के बहुत सारे फेवरेट पार्ट्स नहीं है, लेकिन दो पार्ट्स बहुत इंपॉर्टेंट है. वन इज पार्ट 18 एंड सेकंड इज पार्ट 20. सो पार्ट 18 इज रिलेटेड विथ इमरजेंसी, पार्ट 20 इज रिलेटेड विथ अमेंडमेंट, राइट. सो पार्ट 18 ई होता है, इसलिए इमरजेंसी प्रोविजन याद रखना है. ये क्या करता है? इट एस्टैब्लिशेस अ पुलिस स्टेट. इसका मतलब क्या है कि व्हेन a government is run by appointed officials rather than elected representatives, it is known as a police state. तो यहाँ पे क्या होने वाला है? यहाँ पे emergency provisions की वजह से we are going to have what? We are going to have a police state. It converts federal structure into a unitary one without formal amendment of the constitution. इसका मतलब ये है कि जब हम amendment करेंगे, जब हम इमरजेंसी प्रोविजंस लगाएंगे तो स्टेट का सारा पावर सेंट्रल गवर्नमेंट के हाथ में चला जाता है. व्हेन वी हैव इमरजेंसी प्रोविजंस तो स्टेट गवर्नमेंट का सारा पावर सेंट्रल गवर्नमेंट के हाथ में चला जाता है. सेंट्रल गवर्नमेंट बिकम्स ऑल पावरफुल. और अपने को ये पता है कि जहां सेंट्रल गवर्नमेंट ऑल पावरफुल होता है तो उसको हम कहते हैं यूनिटरी गवर्नमेंट. So whenever emergency provisions are implemented, it makes the thing unitary without any amendment of the constitution. We have three types of emergencies. First is Article 352, national emergency. But a very important fact, word national emergency is not used anywhere in the constitution. I repeat once again, the word national emergency is not used anywhere in the constitution. Article 352, there is a word proclamation of emergency and not national emergency. There is a word proclamation of emergency. It is national emergency. Then comes Article 356 and 365. It talks about state emergency, which is known as constitutional emergency or precedence rule, for which another important article is 365 and another is Article 360 for financial emergency. Till date, we did not have even a single financial emergency in India. Till date, we did not have or we do not have a single financial emergency in India. हमने अब तक कोई भी फाइनेंशियल इमरजेंसी नहीं की है इंडिया में. सबसे बड़ी चीज यहाँ पे क्या ध्यान में रखना है, इस पे मैच द पेयर एक क्वेश्चन आएगा फर्स्ट थिंग. एंड दूसरी चीज क्या यहाँ पे क्या ध्यान में रखना है, द वर्ड नेशनल इमरजेंसी इज नॉट यूज्ड एनीवेयर इन द कॉन्स्टिट्यूशन. देन वी हैव 3-tier structure. We have three-tier government. Three-tier government. In the center, we have central government. In state, we have state government. And at the local level, we have a local government. But famously, this local government is known as development administration. This local government is famously known as development administration. So whenever a question comes on development administration, you have to write about rural local government and urban local government. I repeat once again, whenever in your mains also question comes on development administration, you have to write about rural local government and urban local government, that is Panchayat Raj. Here few important facts which are very essential for your examination. Urban local government, it got constitutional status by 74th Amendment Act. Urban local government got constitutional status by 74th Amendment Act of 1992. Its implementation was started in 1993. The most important article is Article 243 capital W. Important schedule, 12th schedule. How many functions are given in 12th schedule? Total 18 functions are important. This is the most important part of prelims. Most important part of prelims which you have to remember. Urban local government, 74th Amendment Act of 1992. Implementation started in 1993. Important article 243 capital W. 12th schedule, 18 functions. Urban local government includes what? Nagar Panchayat, Nagar Parishad, Nagar Palika, Municipal Corporation, Cantonment Board. That is all urban local bodies. Then comes rural local government, which includes Gram Sabha, Gram Panchayat, Panchayat Samiti, Zilla Parishad. Here one very important thing. I am using a line. Remember very carefully. Gram Sabha is an epitome of direct democracy in India. I repeat once again. Gram Sabha is an epitome of direct democracy in India. It means Gram Sabha is one of the best example of direct democracy in India. Gram Sabha have a constitutional status in India by 73rd Amendment Act of 1992, which was again implemented in 1993. So rural local government 73rd, urban local government 74th. Important article 243 capital G. Which is important schedule? 11th schedule is the most important schedule. How many important functions are given? Total 29 important functions have been given. Total 29 important functions have been given. So what we are studying, many people read Lakshmikant but they are not aware about these facts. We have three-tier structure which includes central government, state government, local government. At local government, we have two important bodies, urban local bodies, rural local bodies. Urban local bodies, urban local government, Nagar Panchayat, Nagar Parishad, Nagar Palika, Mahanagar Palika. Rural local bodies, Gram Sabha, Gram Panchayat, Panchayat Samiti, Zilla Parishad. Urban local bodies, 74th Amendment Act, 1992, 243 capital W, 12th schedule, 18 functions. Rural local bodies, 73rd Amendment Act, 1992, 243 capital G, 11th schedule, 29 functions. Be sorted. You should be very clear about what to read and what not to read for the UPSC prelims. Then we have added a new part into the Indian Constitution, that is a cooperative bodies. Cooperative bodies got inclusion in part 18 of the Indian Constitution. Sorry, it is something wrong. I'll clear this thing. We got cooperative bodies by 97th Amendment Act. 97th Amendment Act of 2011. Cooperative societies have constitutional status. Right to form cooperatives is your fundamental right. I repeat once again. Right to form cooperatives is your fundamental right. So 97th Amendment Act of 2011, fundamental right, Article 19. Also we added a DPSP, Article 43 capital B. New part, it is wrong, new part 9B has been added, the cooperative society. So regarding cooperative societies, few important things. First, 97th Amendment Act, fundamental right 19, then DPSP 43 capital B, part 9 capital B. So right to form cooperatives is your fundamental right at this particular moment. Now, this is the criticism of Indian Constitution. It is carbon copy of 1935 Act, un-Indian or anti-Indian, an un-Gandhian Constitution, elephantine size, or paradise of lawyer, borrowed Constitution. Many of these are the unnecessary criticism of the Indian Constitution. Clear? Now, we'll take a short break. We'll come in half hour, within 30 minutes, and we'll go for another topic. We are going to conduct all these sessions of marathon throughout these 10 days for all UPSC Prelims candidate. Stay tuned to our channel. We'll be coming in just only half hour. Thank you. Have a great time.